What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn.
Wow, my internet is terrible right now. We might not be able to do this stream. I'm gonna start this over real quick. Hopefully, it was just a issue with loading it too quick. Let's try again. What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm Rick.
Man, I feel like I'm on dial-up right now. My internet is slow. Anyways, good to see everyone. Hold on, let me start over. What's going on? This is Colin. How's everybody doing? Happy Saturday. Yeah, hope you guys are doing great. Lone Wolf, thank you so much for the raid. I appreciate it. Yeah, wasn't quite ready yet, but you know what? Lone Wolf messaged me, said he was raiding, so yeah, let's go. All right, I've got 3 clips for you today. I got a Judge Middleton. That's the first one. Second one's Judge Clark. Last one is the magistrate. I don't remember her name. She sits in Magistrate Chisholm's courtroom on Fridays. I can't remember her name off the top of my head. Anyways, I'm glad to see you all. Happy Saturday. You guys ready? Let's go. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
So
And it just always worries me that if I'm missing one little criteria or something.
all right, we're back as I indicated that we would be. We've got 2 sentences to do, one at 10:30, one at 11. Daniel, we're ready.
All right, I think my internet's caught up. All right, we're good now. We're good. I was a little worried that I was going to get cut out. Yeah, I don't know how public I've made this, but I actually reached out to Judge Middleton and he called me back. He's not interested in interviewing for the LawTube community. He has his reasons. I'm not going to make them public, but I have tried, and he actually called back and said no. So I have a lot of respect for him. He didn't just ghost me like a few other judges have. He's professional, which was awesome. Judge Boyd is on my list. I was waiting. I was giving Jen, because Jen interviewed Judge Boyd, and I was letting her video do the circulation before I reached out to Judge Boyd. But Judge Boyd is on my list to do. And I have also got people in ears of others as well. So there are more coming down the line.
Ready to go on Mr. William Everett Lee. I do not think the prosecutor's office will be here. This is a county case. File number is 24743FD. This is a tough case. Mr. Lee is represented by attorney Lori Hines. He was charged with operating while intoxicated, third offense, a felony charge. This is, in point of fact, his at least fourth drinking driving offense. His 3 priors are all in the state of Indiana. Several are quite recent. So it was reduced from a felony to a misdemeanor, and Daniel was assigned to prepare this report. Daniel came to see me earlier in the week, I think Tuesday. I guess it would have just been yesterday.
Dan's out this time.
I think I guess he told me that, and that he said if necessary, Matt or Autumn would know what was going on. Anyway, Mr. Lee has a serious alcohol addiction issues. I read the assessments. It's like I didn't need an assessment to tell me what was going on here, but Daniel's recommendation is quite harsh.
I did. When I met Judge Perkins in person, I asked him, and he gave me kind of a lawyer slash judge type response. He asked me to email him the questions I would ask him, and then he would send the questions to his attorney to see if it's a good idea or not. And he never responded. There are reasons why I believe he responded that way, and it has nothing to do with me. But yeah, I was ghosted by Judge Perkins. I really was.
He's recommending 365 days in jail, 180 days immediately with other factors. So, Ms. Hines, what would you like me to know?
Your Honor, Mr. Lee has taken the recommendation, but the possibility of sobriety court very seriously. He has located a residence in Sturgis, Michigan. I think they can move as early as today. He did get an assessment at the Northeastern Center. I submitted that to Mr. Francine. He works full time. His wife is here. His family is happy that he's taking his sobriety seriously. He's going to AA meetings probably 3 to 5 times a week, if not more. And we're asking for an adjournment today for the possibility for him to be assessed for sobriety court because he's now a Michigan resident.
All right. And Daniel and I discussed that. The problem is he doesn't have a Michigan driver's license.
Okay.
And we can't give him an interlock device unless he has a Michigan driver's license.
And he indicated to me, and I told him that that may be an issue. And he said, I don't even want a driver's license or I want to drive.
Well, so that may be an issue. He certainly needs intensive probation.
Correct.
But you deserve a big bunch of jail time. I appreciate what you're doing now, but you were an unguided missile. And the facts in this case are as bad as I've seen in some time. The more I read it, the worse it got. You got deferred sentence and house arrest in other jurisdictions. And Mr. Frazine said you were taken aback when he said you're probably going to get a big belt of jail time. And that may be a wake-up call. Now, it may also totally disrupt your life. Lose your job, your family's without you for 6 months or a year. In the earlier times, and I've been here for a long time, I've been here so long we didn't even have a copy machine. But if you got this charge, you did a minimum of 365 days in jail. That was the minimum. Some people went to prison. You were just, for one thing, you didn't have a driver's license. Your driver's license was suspended. You were just off probation and you were just cavalierly drinking all day and then driving. I'm going to read the summary from the police report. On May 24th, officers from Sturgis Police Department received a be on the lookout for a Jeep that was driving recklessly down Fawn River Road towards Centerville, failing to maintain the lane of travel. I think more than one person called in. Officers observed the be on the lookout vehicle parked at the Marathon gas station, the intersection of Fawn River. So they positioned themselves to watch you. The subject got out of the gas station, got into the driver's seat. The vehicle exited a gas station south onto South Centerville Road without headlights or taillights. Before turning east onto Fawn River Road, the vehicle continued east on Fawn River Road with no lights on, swaying back and forth in the lane of travel, crossing over the center line and the fog line. The vehicle then approached the intersection, continued south, then disregarded a stop sign, made a right-hand turn, and then they pulled you over and you said, I only had one drink 3 hours ago. And your blood alcohol was 0.32. For extra measure, you had open Modelo cans in the car. And you're a mess. They have to take you to the hospital at 3:02. So they did actually take you to the hospital. Your blood alcohol then came down. So this was bad. You're dangerous. Dangerous down Fawn River Road, dangerous down Chicago Road, driving with no lights on, weaving all over the road, blowing a stop sign, open beer in the car, just like it was another day in the park. We've been struggling recently with Indiana convictions, trying to get a straight answer from the Driver License Appeal Division. We got conflicting answers. I've been doing sobriety court now for more than 12 years, had dozens, maybe hundreds of people go through it. And let's say, like you, somebody has multiple priors in the state of Indiana, including recent ones, and then they get convicted here, charged with a felony, reduced to a misdemeanor. That's really our core group. But then they told us, well, if they have an Indiana convictions, they're not eligible for restoration. You need 2 Michigan ones. And I don't think that is accurate. I know for a fact I've put people in the program before. So we hadn't discussed the fact that you don't want a driver's license because Michigan won't give you one. You can't come into Michigan with 3 recent Indiana drunk driving convictions and a Michigan one and apply for a Michigan license for me to attach an interlock to. I don't think they'll do it. But I'm willing to discuss.
Hey, looking at legal stuff. It's good to see you. Glad I'm happy you stopped by. Can one of my mods please drop her link? She has a great channel. She has a big channel. She's a lot bigger than I am. So thank you so much for stopping by. Also, Wolfie, again, thank you so much for the raid. Another channel who has a great channel who's a lot bigger than me. I'm just trying to be cool like them. I'll get there.
Discuss possibly putting you in the program without the opportunity for a license.
It's gonna be about an hour. As usual, it's a normal live. Got 3 clips. They're all about 20 minutes long.
There's no reason why this shouldn't have been done before. But I think in defense of your lawyer, you lived in Indiana. And I told her if he lives in Indiana, he's not eligible whether I like it or not. In the meantime, you've moved to Michigan or are moving to Michigan. So her question is, are you eligible now that you're a Michigan resident? Have you actually moved to Michigan yet?
Oh, we have started moving some of the stuff into.
Where are you moving to?
It's
I have the address, Your Honor.
What town?
Sturgis on US 12, lot 65.
Memory Lane?
yes, sir. Housing is very scarce in in the surrounding area.
It is. It certainly is.
Yes.
And I deal with landlord tenant cases every day. And it's hard to find a place to move to.
Yeah, we had to purchase a fixer-upper. That's why we haven't fully moved.
They had to replace the subfloor and put a new floor in and do some wall work and.
All of
They've
those
been
trailers
working on
there are old housing stock,
Yeah.
but the rent is expensive. It's $1,000 with lot and trailer rent. But, all right. License. Does not want interlock.
I don't think she's been to court yet, has she? The only thing that's available right now is her arrest. I read the article. I haven't seen anything else. I saw clips of the arrest, but that's it. But yeah, I generally stay away from the police body cam because so many other channels do them. So, less likely of me getting in trouble for using other content that's being used.
Daniel says in his summary.
You don't have to be sorry. No, it's a really interesting case, and it's her second arrest, right? If I remember the article, it's her second arrest. Yeah, it's not looking good for her. It's not, and she had a lot of attitude in the back of the police car, right? Am I thinking of the right story here? I think I am. But yeah, don't be sorry. Don't be sorry. It's a great story.
Mr. Lee told us officers he has attended some classes. He did 3 sessions for OUL second. Whereas he started going to AA meetings every Tuesday and Thursday. And he did have an appointment with a primary care provider. This officer does not believe that Mr. Lee is considering sobriety court because he knows he needs help for his alcohol consumption, but as a way to stay out of jail and possibly get a license. This officer understands this is not untypical for many of our sobriety court participants, but it does indicate where he is likely at the recovery process. I hope it does work out, but Mr. Lee is able to apply and be accepted into sobriety court program. However, I'm structuring my recommendations as if he is not. So sobriety court would be different recommendation than 180 days in jail. It wouldn't be no jail, but we'll at least take a look at it. But when it gets to your 4th drunk driving and you're a serious danger to the people here in St. Joe County by drinking all day and driving terribly without a driver's license in the first place. When I used to do the victim impact panel, when I was prosecutor, I started the victim impact panel many years ago. And I would tell people, I'm not going to say that you're never going to drink again. Just don't drive a car. And you were cavalier about driving a car. You didn't have a Michigan or Indiana license, and you're going here, there, and everywhere, just as though you did. Now you, I guess, acknowledge that you can't do that. How are you going to get back and forth to work?
Me and my wife, we work on the same shift, same.
All right, well, that certainly helps.
And if there would be any jail time, would there be possible I could do on weekends?
Well, it's possible it could either be weekends or work release.
Okay, because I'm up for a promotion at work, depending on.
Well, I'm not oblivious to the fact that this could cost your job, but you need to get a ticket on the clue bus. You get arrested for drunk driving 4 times, you could do a whole bunch of jail. You could lose your house. Your wife and daughter or wife and son won't have your income. They lose your health insurance, although she has it. It's a big deal. And it's like, well, maybe somebody will give me some deferred jail time or house arrest. Eventually, you're going to get whacked. And I don't know if this is the time or not. But as I read those facts to you, they're just terrible. We've had lots of driving fatalities in our county in the last year. As you know, an assistant prosecutor was killed by the head-on collision. She probably actually talked to you about this case. The man then ultimately died. I don't know. I haven't seen the final result. I don't know whether he had drugs or alcohol or both in his system. The presumption was that he did. Another young man was drunk, leaving the bar and hit a tree on the way home and left a wife and 2 kids with no dad. And I could tell you about 6 or 8 more stories like that just from 2024. Unfortunately, you weren't one of them. All right, Ms. Hines, I'm willing to grant your adjournment.
Thanks, Your Honor.
Would you give this to her? We're going to send you downstairs to see Matt. I know you take most of the extended summer off, so do you have any available
It's the
days
spring, Your Honor.
between now and October?
Yes.
All right, let's see.
Other than the 22nd through the 28th of August, I know I'm gonna be coming home.
I don't want to go that far.
I didn't bring my phone with me. So I don't take time off in the summer.
I do.
You do more than I do. I take it off in the spring. That's when we
How about
travel.
Monday, July 8th? Are you available on that day?
I don't know. I'll make it work. What time?
Here's Autumn now. Do you have input on this? Come on up.
Somehow I knew you were delaying me enough until I got up here. So I've already reached out to Secretary of State in regard to Mr. Lee.
Yeah.
She can't tell me definitively if he'll be able to even obtain one
I
until
don't-
he gets a Michigan
Well,
driver's license
I'm
number.
assuming that he will not be able to obtain one.
My guess is he will not.
So he says, I want to do sobriety court, but I'm not going to be interested in getting an interlock.
And unfortunately, at that point, because it's things are grant funded, that's the carrot. That's what people are striving for as a license. If he doesn't feel he needs one and doesn't want one, then I would rather use my services for people that want one, and he can just go on an intensive, regular probation that is centered around a type of sobriety court program. But my hope is he didn't move to Michigan with the intention of going into the program. If that was the reason for the move, then I think maybe he was misled at some point.
All right, well, let's try to break this down a little further. She referred to it as the carrot, in the metaphor of the carrot and the stick, which is a goofy metaphor, but the carrot would be something that the animal would want and strive to get to it. The stick would be you'd hit him with a stick to punish him.
What is goofier, the carrot and the stick? Wait a second. Did he just say hitting him with the carrot? No. You're holding the stick. The stick has the rope with the carrot. That's what it is. So they're constantly chasing the carrot. At least that's what I understood it was. But this is the judge that has the Jabberwocky metaphor. Which one makes more sense, the carrot and the stick or the Jabberwocky? I mean, just asking for a friend.
And so you get some hitting with a stick and then you get some reward with a carrot. Seems like they could have picked something better than a carrot, but the chocolate cake or the stick. Anyway, the people that go into sobriety court, not everyone, but most of them are eligible to get their driver's license with an interlock. So there's a benefit that we can grant only to sobriety court people. You can't get an interlock device unless you're in a certified sobriety court treatment program. So her point is You don't need a sobriety court program. We could do a regular probation with intensive supervision.
So
Yeah.
at least with moving to Michigan, if he doesn't get sobriety court,
Yeah, there's another YouTuber. We're getting a lot of YouTubers in here today. Katie Zed, good to see you. I don't know if my mods have a list of channels for them to constantly drop. I don't know if one of my mods can find your channel quickly, but Katie Zed has a good channel out there. She does a lot of law and crime type stuff, so it's a good channel. So you should go check her out. But Katie Zed, thank you so much for joining us.
he'd still get afforded the ability to do probation.
He would.
So it's not a lose-lose for him, so.
Yeah, and he could also do probation. though, if
And he
lived in
works,
Indiana,
he does
Yeah.
work,
so.
and he works in Michigan,
Well,
so.
so the other side of the equation is sobriety court is very treatment oriented.
Right.
We spent, as she mentioned, some of it's grant funded. We have a grant funded group treatment program. We do testing at the day reporting center. You're required to be in an AA program, and you're required to do individual treatment. You're
Which
also
he's
required
doing.
to do community service. So some of those things he wouldn't have to do on a regular probation. He would still have to test. And he wouldn't, and I could still meet with him. But Autumn's point is, and she's been at this for 10 years or so, is that if we can't give him a license anyway, we don't need sobriety court. We could just use regular probation.
Which he would still have to, on a probation order, have to complete an assessment, complete the treatment. So everything that he would be required to do on a regular probation or in a sobriety court program, he would have to do on a regular probation, minus just the twice a month reporting to the judge. He would still be required at some point
Well,
to
he
test.
wouldn't be in Spencer's group.
Correct, but
but-
there's nothing to
but-
say that they couldn't put him in a treatment group.
And he's already,
is-
he's in a treatment program.
Yeah.
He's,
And he's
No,
going to AA. How many times are you going a week?
About 3 times.
Are you keeping a log of it?
I started keeping a log.
He has a journal. Mhm.
Yeah, I mean, so
no, wait a minute. You've been to AA 3 times?
3
No,
times
a week.
3 times a week.
sir.
Okay,
Yes, sir.
yeah, that's better.
Yeah.
Some programs you have to do 90 AAs in 90 days. But sometimes that's just not feasible.
And it's not the same one. He's done the Sturgis, he's done.
Yeah,
the Grange, he's done
I'm
the
all in
Three
favor of
Rivers.
it. Hopefully he got a wake up call that he's not
Yeah.
gonna
Yes, sir.
kill himself or somebody else.
I think his wife would
Um,
confirm that.
So I don't want him to lose his employment. That's one option. Just give you 180 days in jail. You'll get 5 days a month good time. You'll be out 150 days. If you mow lawns or you're a trustee at the sheriff's department, you'll be out in about 130 days. So
Yeah, this is his 4th DUI, and there a bunch of people called him into the police, but it's his 4th DUI. He had open containers in his car, empty containers in his car. He was it a 0.34? It was something ridiculously high. He was driving around all day drinking, all day.
in the meantime, you're just in jail. And then you get out and I don't have a handle on what you're doing. And I don't also have the prosecutor input. I'm not being critical. They just don't have enough people to go around. But you
I'm gonna put a little selfless plug in here. Vote Debbie Davis. Not enough prosecutors to go around. We have a great friend of the channel. She's generally listening on weekends. Debbie Davis, if you're here, say hi. Yeah, vote for her if you're in the area.
have been involved in treatment. This only happened in May and it's now June. That's pretty much about as fast as it gets, which is what I prefer. if I'm gonna have somebody in sobriety court, I like to get them right in there shortly after the event. We're at May 4th for the arrest and June 19th for the sentence. That's pretty fast for court time. So in that period, you got your assessment, you started going to AA. I'm assuming that you've been alcohol free
Yes.
and you haven't been driving. So those are all pluses. So let me ask you, in the words of Jay Leno, what the hell were you thinking? What were you doing just blasting around all day, drinking from morning to night and driving up here in Michigan?
That day I was celebrating, for becoming a grandfather, and then I don't have an answer for my terrible actions. And I did think which that doesn't help the fact I thought that I had an Indiana license still at the time, but that doesn't, dedicate for me drinking and driving. Because when I went, my license it expired on my birthday, and I had to, get a valid license. And I went to the license bureau and I, relinquished my license and went with just a state issue ID card. No.
All right, so Autumn, if we do a regular probation, what are you recommending?
Well, actually, Dan Frazine completed this
He
screening.
did.
My recommendation would be for him to continue treatment, 24 months probation, eligibility to be discharged in 12 months. I would require him to attend at least.
All right. This is gonna sound really bad, but what are we voting for? I missed something. I have missed something completely. Sashina has some kind of voting thing going on. I have no idea what we're talking about. And I'm probably a bad friend for not knowing. I saw something last night. I think Jay Hart said something about voting for something, and I didn't know what he was talking about. Voting for the Beaver song? Have you not seen the? No, I have not seen. I have not seen the so-called Beaver song. I have not seen it. I have not. Okay, let's keep going. The Drunk Beaver song. Apparently, everyone else knows what it is but me. Yeah, I'm in the dark on the Drunk Beaver song.
2 AA meetings a week, 3 if he wants, with monthly logs sent to the probation officer. I personally would have him start testing 2 times a week at least, with
Yes.
possible reductions after 45 days if he can prove sobriety. Victim impact panel. I think this case warrants some jail. Not out for people to lose their jobs, so possibly have him serve a few weekends.
More than a few. I'm talking like 60 days.
Well, if that's the case, then I would, if it was me, I would request that him be able to go to Twin County, fill out the work release packet program, get it back to them so they can approve it or deny it, and then
Well,
him be able to turn himself in on a Friday night.
let's talk about that. We have work release.
Yes, sir.
We used to do it at the jail, and now we do it at Twin County Probation Center. The legit.
Yeah, no. As good of a friend you are as to me, I don't think you really pay attention to my channel as much as I would hope you do. I don't know how to say this, but no, I did a video on that. I did the warrant and the warrant to show. No, yeah, the warrant reading and the arraignment, and I laughed about it, and I did a video on it, and it's hilarious. But yeah, the Taylor Swift defense failed miserably, and now she doesn't get to go to Europe, at least not till Monday.
Logistics of that are going to be difficult. It's in Three Rivers. You live in Sturgis. You work in Sturgis.
I work White Pigeon.
White Pigeon. All right.
His wife's his drive to work.
All
He
right.
works second shift,
All
right?
right.
Yes, ma'am.
All right. Well, let's try this. 24 months probation. 180 days in jail. Credit for 2. Leaving 178 days. Of the 178 days, 118 are deferred, leaving 60 to do. That's either 30 weekends or work release. There's a $300 fine, $75 crime victims' rights fee, a $50 state minimum fee. I'll cut the screening fee in half, $50, $150 attorney fee, probation oversight fee of $960. It could be cut in half if you do it in a year. There's a police reimbursement of $200, victim impact panel of $32. Testing, drugs and alcohol, 2x per week. Victim impact panel, substance abuse counseling and treatment, no drugs and no alcohol. Do you smoke marijuana?
Yes, sir.
All right, now it's not legal in Indiana. It's legal in Michigan for adults. You can't smoke marijuana while you're in this probation, which makes this even worse in addition.
Okay.
Uh,
Yeah, I can stop that as well.
So are you going to treatment now, but you're still smoking marijuana?
I haven't smoked for probably 6 or 7 days, possibly.
All right, you need to really to get on the clue bus.
And then, yeah.
Well, in Indiana, it's not legal to smoke marijuana or possess it. So you're under the radar on that one.
I've been leaving it at the Michigan residence.
Okay. All right. Well, it's legal for adults in Michigan, but you can't. And if you were in sobriety court, I wouldn't let you do it either.
Okay.
Do you have a medical card?
I was going to apply for one of them once I, gained my residency and kind of went through all these proceedings because.
Well, I'm not gonna, even if you get a medical card, I'm not gonna let you smoke marijuana.
Okay. Yeah, I just have chronic pains in my.
Well, if you stop drinking so much, you might heal your body up some.
Boom. He's not wrong. Stop drinking so much, you won't be in so much pain. It's weird. It's weird. Stop poisoning your body. You might feel better. Right? Kind of weird. Kind of weird.
Now, there's still 365 days held over your head. So if the wheels fall off, you still could get a big dose of jail. I've got 118 days deferred. Let's add all this up. $300 plus 75 plus 50 plus 50 for the screening, plus 150 for the attorney fee, $960 for the probation oversight fee, $200 police reimbursement, $32 victim impact panel is $1,817. Your bond was $50,000 cash or surety, and you posted it. So under the theory that you're a danger, like a assaultive or sexually assaultive person. You weren't assaultive, and you certainly weren't a sex offender or sexually assaultive. I don't want to have any indication that you were, but those people are dangerous to the public. And someone that drives the way you did after getting arrested 3 previous times is a danger to the public. All right, there's not a time to report to the jail. Work release might take a bit. Do you want me to give a date to start?
Well, so if he wants to try work release, I would recommend going to Twin County today.
Okay.
He needs to take that work release packet to his supervisor or his employer. They need to fill it out.
He needs then to return it to Twin County, and then they will approve, they'll contact the supervisor to verify work hours, and they'll approve it. If they do, they normally have them turn themselves in at Friday night at 7 o'clock. That way it would be outside of his works hours, but since he works nights, they may have him turn himself in first thing Saturday morning. And then they would pick him up Saturday afternoon, and then he'd have a day and a half to get settled into the probation center to be able to go back to work Monday afternoon.
All right, we'll have to work the logistics of this out,
So
but
you work Monday.
Monday
through Friday night.
through Friday night, 1:30 to 10.
I sent a message downstairs to the clerk, so she's fully aware of what occurred. So she's gonna schedule an intake with Dan and go over information he'll need to go to the DRC as well to get signed up for testing. She'll go over all that with him.
Okay, he'll go down after. Okay.
Mm.
That's right.
What is work? Do you live in a separate place?
Probation center.
one comment is we've been trying to discern this Indiana-Michigan issue. And as Autumn said, we've been struggling with the driver license appeal division recently. They get the bad consequence of an Indiana conviction, but they don't get the benefit. We had a case where the person was charged with third offense. They had 3 offenses in 10 years, but they didn't have 2 in 7 years. They pled to a second offense OUIL with an Indiana prior that was more than 7 years ago. So the person certainly needed services, was a fit for sobriety court, but we're struggling with whether they can get in or not. And they're not going to give you a driver's license in Michigan under these circumstances. Also, you're revoked. It's going to be very difficult for you to ever get a license. However, if you complete the probation and maintain a period of sobriety and do everything that's needed, you can eventually apply here. And
Wait a second. 4 DUIs, it's possible for him to get a license again? Why isn't it permanently suspended? He's already said he doesn't want to get a license again. He's not going to apply for one. He's done. He's never going to drive again, which that's hard to believe. He doesn't look old enough to make that statement. Something might come up where he needs to drive. Things happen. But 4 DUIs, how are you still even allowed to drive? And a .32.
Michigan for a restored driver's license with the traditional driver license restoration with an interlock just wouldn't be through sobriety court. So you go downstairs to probation and I'll give you this form to take down there.
I think,
60 days is a gift.
yes, you have to decide.
Last words from Judge Middleton. 60 days is a gift. And I agree. It is a gift. If he wasn't working so hard between the time he got arrested to work on his sobriety and the day of sentencing, he would have done the full time, wouldn't have been granted a work release. At least I believe that. He was working on it. Whether or not he's doing it, out of fear or doing it because he wants to, who knows? That's a different story. But all right, next one. Next one, we're going to a bad guy. Or allegedly a bad guy. And this is a follow-up to something I did about 2 weeks ago. It was another weekend case. But this guy, the crime that he committed is one of the worst ones that you can commit. That's not ending someone's life. And I think you guys know what it is. You'll see. This is the guy whose defense attorney is trying to get his entire case thrown out, or he's trying to suppress evidence because the victim statement said that this act happened on a purple car, I think it was, and the car was sold like 5 years before the act happened. So they're trying to throw the entire case out because of that. So, all right. This isn't a fun case, but it's Judge Clark. Yeah. All right. And it's a follow up, so I'm gonna play it. All right, let's go.
Mr. King out. Come on up, Mr. King.
Oh, this might be a good case for you. You can use the content. You can go back and look at it. I can find you the day that I covered his first hearing. It was about 2 weeks ago. I generally cover the tougher cases over the weekends because content's slow, or court's slow. Let's say that. And but the last case he had, Judge Clark said that he was going to take it under advisement and come back and rule on it. So this is them coming back and ruling on it. His attorney's still doubling down on all the facts. We'll see what goes on.
Set today on the motion to dismiss. The state has filed a traverse, and the defense has filed a motion to strike the traverse. Any other argument? I reviewed the motion to dismiss the traverse and the motion to strike the traverse. Does anyone else want to put anything on the record? King?
Your Honor, thank you. And we've been here multiple times on this motion, so I'm not going to belabor it, but just for the purposes of the record, I think there are two principal takeaway points that I'd like the court to consider for the purpose of the motion to dismiss. There are two issues that we focused our argument on. One being is that the centerpiece of the charges against Mr. King in this case revolve around the allegation that Mr. King basically groomed this particular alleged victim around about 2018 when he initially engaged in sexual acts with her on the hood of a purple car owned by the alleged victim's mother. We've established via undisputed affidavits that the car in question was sold in 2013. Now, I realize you've had the opportunity, Your Honor, to review the affidavits, and we've addressed this in the motion to strike the traverse. I realize that the state has filed the traverse, but we would argue respectfully that the traverse is self-serving. All that they've said is that this is disputed. As the case law that we provided in our motion to strike is pretty clear, the state can't just say, we don't agree. They have to give specific facts as to why that is disputed. So it's not disputed by virtue of the fact that there hasn't been any specificity outlined in their traverse as to why that is a disputed fact. It has to be deemed admitted by the court. And if it's deemed admitted by the court, that means that the grooming act, the initial threshold act that started this whole alleged chain of events in which Mr. King allegedly sexually assaulted this alleged victim for years and years and years, never occurred because the initiating threshold event took place on the hood of a car that was sold 5 years before by the state's own admission, and by the alleged victim's own admission 5 years before they even met. So while the state has attempted to boil this down to an issue of credibility or the weight of the evidence, it's not. It's a binary choice. It's a binary issue. The car in which this whole situation occurred was either there or it wasn't. And if it wasn't there, then the initial act didn't occur. And if the initial act didn't occur, none of this occurred. The second point is, Your Honor, and again, we've moved to strike the traverse, but this is the second other point that I think the court needs to consider as a takeaway. Again, and I don't want to overemphasize this, but the alleged victim in this case has suggested that she was assaulted by Mr. King 60 separate occasions in which Mr. King forced her to perform fellatio on him. She was not able to identify whether or not Mr. King was circumcised. That in and of itself should tell the court that this did not happen. But while we've asked the court to strike the traverse, the dicta in the traverse is actually helpful to us because Mr. Sullivan cited that, although we disagree that this happened, but assuming it was true, Mr. Sullivan.
All right. We disagree that this happened, but assuming it's true. I mean, come on, you're a defense attorney. Use better words. Why are you assuming it's true? Especially, you're saying the opposite of what you just said. You're contradicting yourself. There's a word I was looking for. Also, Katie said, no, I agree. I don't like sharing this on my channel, though. I like to keep it kind of light. for the most part, light, somewhat funny. That's kind of the image I try to go with, but but I do agree, which is why I do share these clips. But I do usually save them for the weekend. Oh, one pause, Philip. Thank you so much. Member for 1 month. That is awesome, Philip. Thank you so much. I appreciate it.
That Mr. King allegedly sent photographs of his genitalia to this alleged victim. If that were true, not only are we dealing with a scenario in which he allegedly forced her to perform sex 60 times, fellatio. Now, this alleged victim has the photos on a phone of Mr. King's genitalia, in addition to the 60 discrete acts of fellatio, and she still cannot determine whether or not he is circumcised or not. This is not weight of the evidence issue. This is not credibility issue. He either is circumcised or he's not. No one would not know that if they had photographs and were asked to perform fellatio 60 times. She's lying, Your Honor. There's no reasonable takeaway from that.
You say she's lying.
Credibility issue.
Isn't that a jury question right there? When you make the statement, she's lying, how can I make that determination on a motion to dismiss? I mean, if you're saying, you're arguing me, Judge, she's lying, isn't that a question, the ultimate question for the jury? Or if there's a non-jury trial, that would be the only way I would make that determination.
There is no way.
Wait a minute, listen. I understand your argument. It may very well be true. She is lying. I don't know, but I haven't been. But I'm not on the jury now. If you want to, the only way I think that I can make that decision is if it's a non-jury trial, whether a witness is lying or not.
There are certain things, Your Honor,
there are certain things, Your Honor. Okay, I'm going to say this. And I can't believe I have to say this to all 141 of you watching. Why are you putting yourself as an adult in a position that this could even be accused? There's no reason for that. Zero reason to be put into a position where you could be accused of this. I can count on one hand how many times I have been alone with someone under 18 that weren't my kids in the last 10 years. Zero. Now, I understand there are circumstances, maybe you're younger, you're babysitting, whatever, but 0 times. That's not hard to do as an adult. 0 times. Don't put yourself into a position. Is it possible that this teenager's lying? Yeah, it's completely possible. These are just alleged facts. But don't put yourself in position because humans lie. Teenagers lie. So if this teenager is lying on you, you put yourself in a position where it looks bad for you. Just don't put yourself in a position. End of story. Then you don't have to be sitting there in jail clothes in the court. If in fact the victim is lying, that's an if. There's a lot of details in this case. You got to go watch the first half of the video. I'll go find the link and throw it in the description. I feel like a lot of you may not have seen the first video, but I'll go through that in when this video is over.
Consider all those. I have to consider what the evidence is. That's not the part of a C4 motion.
I think there gets to a point where the evidence is so compelling that there is an objective determination can be made.
I don't believe so.
Now
I'm gonna take it under advisement. I've reviewed everything. I'm ready to give an order, and you'll get an order probably within the next 10 days.
I appreciate that, Your Honor.
When you say she's lying, well, she may very well be, but that's the state's burden over. The state presents the evidence, you present a defense, and then the jury makes that determination whether she's telling the truth or not. So
I understand, and I'm making these arguments for the record, Your Honor.
I understand, but I'm trying to understand it. But when you understand everything, but when you say she's lying. Yeah, well,
when we have undisputed facts such as an initiating act on a car that was sold 5 years before, that's not an issue of whether she was lying or not. We've proven she's testified that she had sex on a car for the first time with a man. The car was sold 5 years. We're going with their facts. This car was sold 5 years before.
Judge,
so how is that not objectively impossible?
Because Judge, that's not a state's fact. That was specifically denied in my traverse. I'm disputing that fact. The fact that this car was sold 5 years before is a material fact in dispute in this case. And Mr. Frank keeps saying this is an undisputed fact, but what he's relying on is an affidavit by a defense witness. So what the defense wants you to do is believe that the victim in this case is lying, but all the defense witnesses are telling the truth, and these are undisputed facts that everyone agrees with. That's not the case. And that's why there are disputed facts that are material to this issue, and why the defense motion should be denied.
Okay. But he has to deny with specificity under the case law. He can't just say, Judge, we don't like that fact, so we're going to deny it. He hasn't said why he's denying it or what facts he has which show that there's a dispute of fact. What is the facts that he's relying on that demonstrate a dispute of fact? He said that twice. This is the third hearing we've had where he said that's in dispute. Why is that in dispute? He can't just say no.
The victim said it happened on this car. Your defense witness said that the car was sold. That's a disputed fact.
There's no, the victim.
Chris Barton, good to see you. A couple weeks ago, I promised I'd give you more shout outs, and I kind of failed in the last probably 2 weeks. But thank you so much for hanging out with us tonight, Chris. Or tonight, it's not night. This is my random middle afternoon stream. So thank you for hanging out with us this afternoon.
Victim also said that it happened in 2018. We've established the car was sold undisputably 5 years before.
Okay, all right, I understand. All right, taking under advisement. I'm ready to set it for trial, though.
Oh, this is 100% trial. I'm jumping ahead though. Let's let Judge Clark finish this off.
Go ahead. What you got?
Well, so there are outstanding defense depositions that we're waiting on. I believe they're scheduled in July. Additionally, Mr. Frank, last time we were here, provided me a flash drive. I'm handing it back to him. That has the cell phone downloads that were done in this case on him, with the exception of the one cell phone download that contains child porn. Obviously, I can't provide that. So making record clear, he's got the other cell phone downloads, but the one that, in my opinion, is the most inculpatory, it's got the most incriminating evidence, I can't provide to him. He needs, again, to schedule an appointment with the Panama City Police Department. I'm happy to be there as well for him to review that evidence.
We've reviewed it previously, but we need to go back because there's been a re-download.
All right, I'm gonna task both of y'all setting up an appointment with Panama City Police Department to go see that, to go review that evidence.
I will do that again. And Your Honor, we do have, in addition, the motion for to reinstate and modify bond.
Okay. All right, are you ready to go forward on that?
I am, Your Honor.
Sullivan, you ready to respond?
Yes, Your Honor.
Okay, go ahead and call your first witness.
Yes, Your Honor. Well, I was actually just going to provide argument.
Okay, go ahead then. I'll allow you to make your argument. Then, Mr. Sullivan, you can respond.
Yes, Your Honor. Previously, there was bond in connection with this case, and for the record, Your Honor, the bond that was.
Are you referring to the hearing that I covered? If you're asking for the actual date of the hearing, I don't know. I covered it. Again, you know what? I'm not going to be able to look for it while I'm streaming because, yeah, my internet sucks. So when I try to multitask on my computer while streaming, it slows everything down. But I will, right after this video is finished, I will post the link to the first hearing in the description. So just look for that after about 10 minutes after this video finishes. But I don't remember the actual date, no.
That you had previously set was, with regard to the 5 counts, was 35, 35, 15, 10, and 10, respectively. You had revoked that bond when Mr. King was picked up for having possession of drugs while he was driving. This was in excess of 2 years ago. Mr. King has since been incarcerated again in the Bay County Jail. Mr. King has, in connection with this particular case that has not been tried yet, he's already served 3 years. And again, we're still waiting, and we're going to set the trial, obviously, once we do the discovery, finish the discovery we just talked about. So again, Your Honor, to emphasize a couple things. One is that he served 3 years already on this in connection with this case. We don't have any issue with the bond that was set in the case where he was picked up for the drugs. It was actually fairly de minimis, but you did revoke the bond on this case, and we're looking for a reinstatement. One of the main things that you have to look at, Your Honor, under the analysis, and we did address this in the motion, is the weight of the evidence. Obviously, I think the motion that we just had a few minutes ago speaks volumes to the weight of the evidence that we're looking at in this case, and a lot of the many infirmities and weaknesses in the case that exist. But I did want to. There are some other collateral issues I'm going to get to, but there is so we're asking for a reinstatement of the bond, but we're also asking for a modification, and I'm going to get to that in a moment. Mr. King has children. Since he's been in the jail for the last additional 2 years, his house is actually burned down, and he has children out there who need his help and assistance. He hasn't been able to earn any money to help to take care of them. The last time he was out for a considerable period of time, he didn't go anywhere. He appeared for all of his appearances. He's from here. There's no risk of him going anywhere. The other issue, Your Honor, that has come up, and I'll just give you a little bit of context. We took the deposition of, there's a third case, and I'll point out to Your Honor, where a bond has been set, where he has again been accused of lewd and lascivious touching of a child. I believe that's there was a bond set in that. There's an open bond set in that case for the two
He's got another charge with something with the minor. I mean, again. All right, not jumping to conclusions. There's still allegations. There are still allegations. It's really hard sometimes, though. Some people make it really hard to try to remain neutral.
There's only 2 counts, but for some reason, when I looked at the docket, it said that there was 3 counts, and they were
only 2 counts. That is 2 counts too many. How does this defense attorney say this with a straight face? There is only 2 counts.
Set at 50, 50, and 50 apiece, and that was I'm looking for the case number right now.
It's 224453.
2244. And to give you some context on that case, Your Honor, we took the deposition of the alleged victim in this case that we're here on today on the motion to dismiss, 4428. A couple days before I took the deposition of the alleged victim in this case, an anonymous call was made to the Florida Abuse Hotline, again, alleging the same abuse, right before our deposition, alleging the same allegations that were made, except this time, whoever was calling on behalf of the alleged victim, I don't know if it was the alleged victim or not, because it's confidential under Chapter 39. This time, not only did they make the identical allegations right before the deposition, they claimed that Mr. King was using the alleged victim as a drug mule by inserting drugs into the alleged victim's vagina. This was about 4 or 5 days before we took her deposition. We took her deposition in October of 2022, I believe, and obviously what she testified to has been the subject of the motion to dismiss. Several days after we took the motion to dismiss, we did the deposition, Detective Shea from the Panama City Beach Police Department, or the Panama City Police Department, just took it upon herself, even though there was no complaint, to go to a co-defendant in the drug case to talk to her children, and magically and mystically, these lewd and lascivious charges manifested themselves in this other case. There's been no evidence given of any of it yet. We haven't seen anything to substantiate these charges. The woman who was the co-defendant in the case has since entered into a plea bargain. I think she's even left the state. We haven't seen any evidence of any of this. It seems to be kind of piling on, and it seems to be an effort to, when this case was falling apart, they wanted to put, it looks like, just based on the timing, because there was never any complaint from the alleged victims in that case. So we don't think there's any merit to that. But we do believe that that reinstatement of the bond is warranted, given he served 3 years on this case. And he served, he showed up for all of his hearings and everything else. He's not going anywhere. He has children that he needs to take care of. Obviously, he's willing to.
You said it exactly right. He's not going anywhere. You know, defendants should not be saying much, right? Defendants should say as little as possible, let their attorney speak. Sometimes attorneys need to shut up too. He is saying way too much. The other case that's involved, is that even part of this? Why did he even bring that up? That just made his client look worse. Is that holding him as well? If it is, Judge Clark can't do anything about that case. He's only here on the case that's in front of Judge Clark. So bringing that case up did not help his client unless that same case is in front of Judge Clark. But if that's not on the docket today, he doesn't have to file in front of him. There's a time and place to argue for different things, and bringing up the second case did not help him at all. I think this attorney has drank the Kool-Aid of this guy. I really do. That's my opinion. They're still alleged, but there is way too many accusations in front of this guy to say that he's innocent. Just saying. Okay, let's finish this one off.
Abide by whatever terms the court sets. Given his lengthy stay, he's of nominal financial means. So to the extent that the court is willing to reinstate the bond, we'd respectfully request that the bond be reduced for these counts. And we'd also respectfully request that the bond on the other case, the 50-50-50, be reduced to a more reasonable amount so that his family can possibly put together the funds to make that amount so he can get out. And also, Your Honor, from a more pragmatic perspective, since we are going to trial, it would certainly make it a heck of a lot easier to work with him to prepare his defense.
Mr. Sullivan, state's response.
The state's asking that his bond remain how it is. The only thing that I do want to address, Mr. Frank mentioned that he's not seen any evidence in the 22-44-53 case to substantiate the charges. That could be because perhaps, despite filing a notice of appearance in December of 2022, there's never been a demand for discovery filed in that case.
All right, what I've got for me now, I've got someone who was out on bond, and since he was out on bond on the case number 20, CF 4428, he's been charged by way of an information. And case number 22 CF 2060 with possession of cocaine with intent to sell, possession of marijuana with intent to sell, possession of paraphernalia, and driving while license suspended or revoked. And also in case number 22 CF 4453, has been charged by way of an information with one count of lewd or lascivious molestation, one count of lewd or lascivious conduct. So what I will do is I'm going to deny the bond to reinstate the bond. I am going to reduce in case number 22 CF 4453 $50,000 on the count that was not charged, according to the information that was consolidated into the cases that were actually charged. We need to keep this winter deposition set.
The first week of July, Your Honor.
Let's set this for July 18th at 9 o'clock.
Yes, Your Honor.
This is my old one. This is at 9 o'clock, and then we should be able to be ready to set up a trial then. Okay?
I think we should be, yes, Your Honor.
And you should get an order within the next 10 days.
Thank you very much. I appreciate your time.
Pardon? July 18th.
All right. Sorry, that was a heavy one. But because I covered the first part, I wanted to cover that one. And I will be watching July 18th. If it gets worse, I may just push it off to Katie's head. If you're still here, I may just give you all the information. Like, you take it. This is too hard for me to do. And it is. Those cases are hard for me to do. But I do really respect Judge Clark, so I watch him every day. Anyways, last case is a short one. This is a traffic ticket. It's lighter when it comes to the offenses. This dude was just flying down the highway and he gets yelled at by the officer in court. Okay, let's go.
Is this? Okay, that one's ready. What else is ready? Okay, but they're not here yet, right? As soon as they come on, put the first one into a breakout room. Thanks. Okay, so let's go with number 2, Horniak, calling the case number of SP 4373340. This is the state of Michigan versus Mark Edward Horniak. Your appearance, please.
Trooper Daniel McLaughlin.
I know Horniak is on here. I named the wrong person. Okay, I'm going to ask you to unmute, sir. Your name, please.
Mark Horniak. Good morning, Your Honor. Good morning.
Good morning. Did you hear the explanation that I gave the driver before you?
Yes, I would like to admit guilt with explanation.
Okay, what would you like the trooper to hear about you, sir?
Good morning, sir. On Sunday, that was Mother's Day. I was speeding, I was running late for work. I told the officer that, and the reason I was running late, my daughter came home from college and
Yeah, his last name is a little humorous, but at least it's not as bad as everybody talks about me. Oh, was that what it was? Carlos, everyone talks about me. No, I think that's what it was. The video I had of last night. The guy's last name was Everybody Talks About Me. Anyways, let's go.
before dinner. It's not an excuse, but when I looked in my closet, I had access. I had a plumbing job I was doing, and the cat got in the plumbing access code, so I had to try to find the cat. By the time I secured everything and left, I was running late, so I apologize for speeding. Please take my past record into consideration for reduced points due to insurance premiums, and pretty much what happened. Just a bad morning, running late early, and got worse from there.
Anything you would like the court to consider, Trooper?
There is, but if I may, Your Honor, Mr. Horniak, I'm gonna be very frank with you. You running late for something or not getting there at all, what's more important to you?
Sir, you're right, 100%.
105 and opposed to 70 is 30 miles an hour over the speed limit, and there is no chance that anybody's going to survive in the event that a collision takes place. You see us out there day in and day out dealing with fatal crashes, and speed is one of the number one factors. Last thing I want for you is to not make it home to your daughter who just got home from college or work so you can provide for your family. Do you understand? You've been driving long enough to know that you should be doing the speed limit no matter the circumstances. Okay? I'd be willing to work with you. Absolutely, no hesitation, but you're unfortunately going to receive something. It's going to be 6 to 10 is what I'd be willing to take the charge from 30 over to 6 to 10 if the people in the state of Michigan allow it. Okay.
Thank you.
Get him, officer. Get him. 105 and a 70. Yeah, don't do that. Don't do that. Never good. Once you hit triple digits, you're gonna be late. You're gonna be late. Just slow down. Just slow down at that point. The difference, unless you're traveling long distance, which you still shouldn't be traveling that fast, going triple digits is only going to get you there 30 seconds faster. If you hit the green light and off on the off ramp, don't do it. It's dumb. All right, I'm gonna let this video play out. Thank you guys so much for hanging out with me today. You guys are awesome. Lone Wolf, thank you so much again for the raid. Katie Zed, thank you for hanging out. Looking at legal stuff, thank you for hanging out. You guys are awesome. I hope you have a great rest of your Saturday. I am off tonight. It's date night with Heather, so I'm going to be hanging out with Heather. I do have a scheduled video that's going to be released tonight, but yeah, that's not till 8 o'clock. So you guys can look forward to it then. You guys are all awesome, and I'll catch you guys later. Until next time, bye.
Sure, and I apologize. Since that day, I've really paid
It's not
attention.
apologizing to me. It's going to be me having a knock on your family's door, letting them know that you weren't coming home today.
That's what you told me that day, and I
Okay.
haven't forgotten that.
All right.
Thank you.
You always keep that in the back of your mind, okay? Defensive driving is what's going to save lives.
Thank you, sir.
Okay, so Trooper, you stole my thunder.
Sorry.
Normally, that's the speech, but I need to say this. When I see traffic tickets that have 3 digits in them, it really sounds an alarm. I drive on these roads. My staff drives on these roads. When I get on 75, the state police are parked there, and I can never see if it's someone that appears for me by Zoom, but it's just not acceptable. It's just not acceptable. But I would rather you receive this ticket and learn the lesson, thank the universe, and rather than read about a Ram pickup truck in some bad situation. So we need to slow down. That's all I'm going to say, because you're going to live to regret it. So limited access 6 to 10 over is $135. Do you admit responsibility to limited access 6 to 10, sir?
Yes, Your Honor.
Okay, and how long do you need to pay?
1 week would be
Okay,
fine.
the court gives you 7 days to pay. You can pay online, in person, or online, in person, or by check. Okay?
Thank you, Your Honor.
That concludes your hearing. When you go to pay online, make sure it shows the updated charge, okay?
Yes, thank you, Your
Okay,
Honor.
thank you. Take care.
You too.
Okay.